Good morning, everyone, and welcome to the next in our series of DMH Stallard webinars in July on this lovely sunny day. Thank you very much again for joining us, and welcome to any new people that haven't joined before. For those that don't know me, I'm Emily Wood and I head up the real estate disputes team here at DMH Stallard. The usual format for today: within about the next hour, we will have 4 speakers for you on various topics to do with property. This morning, we've got Kristine talking about the impact of a commercial tenant's restructuring plan on its commercial property space, a useful tool that tenants may be seen to use to potentially absolve themselves of certain liabilities under their commercial leases going forward. We've then got Jonathan, who will give us a useful reminder of the rules that apply to charities when they are disposing of property and land. Chloe will then speak to take us through the world of planning in relation to the high street. And then finally, I'll share with you the results of a recent survey we ran in relation to post-pandemic workspace. As I say, we should be done within the hour. We would love your questions and comments. Please do use the Q&A function on your screens to submit any questions or just general comments. If you are having any technical issues, then please use the chat function and one of our team will help you with those. Just to say, in terms of the Q&A, unfortunately, Kristine won't be able to stay with us until the end when we'll deal with all questions that we receive. But if you do have any questions for her, she'll come back to you after the webinar. Okay, so shall we begin? Over to you, Kristine.
Good morning. My name is Kristine Ng. I am a senior associate solicitor in this firm's real estate disputes team with Emily. This morning, I am going to discuss the impact of the new restructuring plan regime brought in under the Part 26A of the Companies Act 2006 and its effect on the commercial property sector. Next, please. So, what is a restructuring plan? Last year, when the pandemic hit, the government brought in a package of emergency measures in response. This included the Corporate Insolvency and Governance Act 2020. This act introduced the new Part 26A restructuring plan regime into the Companies Act. Essentially, the restructuring plan is a compromise plan made by a company in financial distress to its creditors. It is aimed at eliminating or alleviating the effect of the company's financial difficulties, such as existing debts, including rent arrears under a lease. A restructuring plan has to have 75% approval from each class of voting creditors. A restructuring plan can also be sanctioned by the court. So this is the main feature and most important feature of a restructuring plan. It is a cross-class cram-down provision. In effect, it is an overriding mechanism whereby the courts can order or sanction the restructuring plan so as to bind all classes of creditors, including those who had dissented and did not vote in favour. Next, please. So for a court to order a cross-class cram-down, there are 2 statutory provisions that it must be satisfied. The first is that the court must be satisfied that if the plan is sanctioned, none of the members of the dissenting classes will be any worse off than they would be in the relevant alternative. The relevant alternative is whatever the court considers would be the most likely to occur in relation to the company if the compromise arrangement was not sanctioned. So in the context of a company in financial distress, the alternative would be administration or liquidation. And the second condition is that the Part 26A restructuring plan has to be approved by at least one class of creditors who would receive a payment or have a genuine economic interest in the company in the event of a relevant alternative. Essentially, this means that if there was to be a relevant alternative, such as administration, one class of creditors must have a genuine economic interest being payment under the administration. If these two conditions can be satisfied, the court has discretion to impose a cram down so as to bind all dissenting creditors. Next, please. To illustrate how this works, I'm going to use the recent and well-reported case of Virgin Active. As you will all remember, last year, the government imposed restrictions and lockdowns where the gyms had to close. Virgin Active is a chain of gyms, and it is also a corporate tenant. Virgin Active put together a restructuring plan under the new Part 26A, and it classified its creditors into different categories. The first would be secured creditors. In respect of its landlord, the landlords are divided into 5 classes, A to E, and then finally general property creditors. The proposals under the restructuring plan differ depending on what class you were put in. So a Class A landlord would have all of its rents paid and have a guaranteed fixed rent under the scheme. All the way down to Class E, those landlords would get 0 past, present or future rent, but in return they would get a restructuring plan return, which is essentially a share of a profit in the future. Unsurprisingly, the landlords in Class A voted in favour of the restructuring plan. All other classes of creditors did not vote in favour. Next, please. As Virgin Active could not get 75% of all its creditors to agree to the restructuring plan, it applied to court to ask the court to sanction the restructuring plan. The judge, when considering whether or not to cram down by sanctioning the RP, it had to consider the 2 statutory conditions discussed earlier. The judge, in this case Mr. Justice Snowden, he was satisfied that on the evidence before the court, none of the members of the dissenting classes would be any worse off under the Virgin Active restructuring plan than in the relevant alternative, and in this case, it would be administration for Virgin Active. Secondly, it was not in dispute that there was at least one class of creditors that approved the plan, that being Class A. Justice Snowden dismissed the objections of the dissenting landlords and ordered a cross-class cram down. That meant that the restructuring plan was applied to all Virgin Active landlord creditors, including those dissenting. I think in the last week or so, a new case came out called Hurricane Energy. In this one, I'll just point out that the court did not order a cross-class cram down because it was not satisfied that the shareholders in this case would be no worse off. So that's just to show that the court doesn't just rubber stamp the wishes of a company in distress. It does look at it quite carefully. Next, please. So what is the impact of these new restructuring plans? As demonstrated in particular by the Virgin Active case, it is a very useful tool for commercial tenants in financial difficulty. And I think that restructuring plans may be used more in the future, as it can be used to restructure debts, past, present and future, and in the case of the corporate tenants, to the detriment of landlords. As seen in the Virgin Active case, it's detrimental to landlords potentially because it can be used to restructure lease liabilities, and in essence, it can be used to compromise liabilities in respect of leases that are not considered essential to the future of the business. Whereas normally, a landlord can take enforcement actions such as debt proceedings to recover the debt for arrears of rent. If a restructuring plan is sanctioned and there is a cross-class cram down on those dissenting creditors, it would bind, and those landlords cannot take any further action such as debt recovery. Another benefit for a company in distress, so again, corporate tenants, is that they can front load an application. It can use expert company and business valuation to essentially build their case and compare the scenarios of a restructuring plan versus the relevant alternatives such as administration, so that they can satisfy and put evidence before the court that the restructuring plan will be the better option for all creditors. This does cause difficulties for landlord creditors, because what they would have to do is come up with their own valuation evidence to counter that of the company. This is going to be a very expensive exercise, often required to be completed within a very short period of time, and the creditors may not be able to get information from the company in order to prepare a proper valuation. So that's a challenge there. Next slide, please. So what can be done if you find yourself with corporate tenants in financial distress? You should participate in any restructuring plan that the corporate tenant puts before you. Attend the convening meeting, which is the meeting of creditors, and vote against the proposal. You should also attend the following second hearing, which is the sanctioning meeting, and object to the restructuring plan. Essentially, at this point, you would have to have, ideally, the evidence to counter the company valuation, so that you can show the restructuring plan does not result in a better result for the creditors. Going forward, what else can be done? I think there'll be a shift in the focus on the financial capability and performance of tenants. So more stringent kind of drill down into the tenant's underlying business to see how healthy it is. I think that also has a knock-on effect on bank valuations, to whether or not to lend to portfolios, etc. So instead of just looking at what rent's coming in, I think banks may also look at the landlord's tenants and have a look at their businesses. With that in mind, going forward, perhaps landlords could look to negotiate kind of lease clauses obligating a tenant to provide regular reporting as to the health of its business. This is quite novel, so there's a little bit more than a turnover rent. It's actually drilling down to have a regular reports as to how the company is performing, not just the turnover. But that's something to be negotiated, and to see how willing tenants are prepared to hand over that information. Thank you very much for listening. As Emily mentioned, I am going to have to sneak off because I've got something urgent to deal with. But if you have any questions, please do feel free to email me. I will now hand over to my colleague, Jonathan Crook.
Good morning, everybody. It's good to see you all again. I am going to run through the general rules behind the situations where charities are disposing of their properties today. DMH Stallard act for a lot of charities, large parts of my work, and so it's something I come across very regularly. And I thought it should be useful as a reminder of what happens, of the extra complications. And I should have said, for those of you who don't know me, I'm Jonathan Crook, real estate partner at DMH Stallard. So next slide, please. So the charity legislation is relevant on most transactions for charities. And it's worth bearing in mind when you're dealing with transactions for charities, maybe setting out the heads of terms for those transactions, that there is some extra time you often need, some extra steps, and bear that in mind in the timing for the transactions. The surveyors among you who are listening today will be particularly involved on the sales, and you'll see I come later that often a special report has to be prepared by a surveyor for a sale to go through. There's been legislation governing charities, what they do with their property, for many years. It changed quite substantially in the early 90s with the Charities Act 1993. Before that, you generally had to go off to the court or the Charity Commission to get approval to sell your property. So the Charities Act 1993 made it rather easier. The aim was to make it easier for charities to dispose of their property, but equally to ensure that charities look after their properties properly, and at the most basic, that they're not sold at an undervalue. So we're trying to protect charitable funds. In 2011, there was a new act came in, the Charities Act 2011, but thankfully for us on this occasion, the law relating to the sale of properties by charities didn't actually change. It was just brought together into a different act. The sections changed, but the law didn't change. There are some exemptions from the rules I'm going to talk about, but time doesn't allow for me to go through those today. Next slide, please. So the general rule is still that a charity can't dispose of its land. And by dispose, I mean more than just sale. I'll come back to this in a minute, but it covers certainly leases and some other transactions without an order of the court or the Charity Commission. Now, you're probably sitting there thinking, well, hang on a minute, most of the sales I do by charities, we don't go off to the court or the Charity Commission. And that's right, because although that is the general rule, that's the exception rather than the rule, as disposals are excluded if they're made to someone who isn't connected to the charity and if various procedural steps are followed by the charity. Now, as I just mentioned, disposal is a wide word and it covers more than you might think. Clearly, sales are covered, covers leases, but the two that are perhaps less obvious and sometimes cause problems, surrenders of leases are covered as well, because you're transferring your lease to the landlord, and granting easements. So if you're entering into an easement to an electricity company, for example, that is also covered. So these are all disposals by a charity that have to be covered by this act. There's no de minimis level, so that these rules will apply to a strip of land in the back garden, as well as they do to the sale of a large warehouse. There's no exclusion if it's a small sale, so that's important to bear in mind. I mentioned connected parties. They include trustees of the charity and donors. And clearly the concern here is there's more danger if you're dealing with a connected party. In those cases, you cannot use the rules I'm going to talk about with the Surveyors report. Next slide, please. With sales and longer leases, so I'm just going to close the door because I've got some noise behind me. Apologies. Right, with sales and leases which are for more than 7 years, one set of rules applies. This also applies to easements and to deeds of surrender. What the trustees of the charity have to do is to obtain and consider a report from a qualified surveyor. So many among you will have done this, I'm sure. Advertising is nearly always required and considered very important. And the trustees have to decide that the terms for the sale or the lease are the best that can reasonably be obtained for that charity. Importantly, the report is not quite maybe the standard report the surveyors will be used to. It's got to comply with very detailed regulations which were imposed in 1992. I'm so sorry, I'm just going to close my window. Apologies. You need the report before you complete the transaction or before you exchange contracts if there's a contract beforehand. So if you enter into a contract to sell the property, you've got to do it beforehand. If there's an agreement for lease, you need to do it before that as well. Next slide, please. Okay, so here, this is an exemption, not an exemption. This is for leases which are for 7 years or less, so shorter leases. It's a slightly more relaxed approach in this case. In this case, the charity trustees take advice from a person with requisite ability and practical experience, and usually, again, that will be a chartered surveyor. Now, in this case, you don't need the formal report I'm going to talk about in a minute. I think you probably would often get a report of some sort from the surveyor, but you don't need to go through the very detailed regulations as you do on sales and longer leases. In this case, the terms of the lease have to, again, be the best that can reasonably be obtained for the charity. This is a slightly more light touch approach, only applies for leases for 7 years or less. It's quite easy to remember because it's similar timing for leases that need to be registered over 7 years. So same rules apply. It's more complicated, more detailed for leases of over 7 years for the charity legislation. Next slide, please. Now, the regulations are crucial here. As I said, they came out in 1992. And they're only about 2 or 3 pages long, but there's an awful lot of detail in there. And there's perhaps a little bit more than you might think. I think it's here that the lawyers and the surveyors can work helpfully together. And I quite often like to see a draft of the report before it's issued formally. And I wouldn't dream of touching the section in the report dealing with what the surveyors are advising on the rent. But where I feel we can add value is just to check that the surveyor is covering all the paragraphs in the regulations which have to be covered. I'll just quickly go through some of the requirements of the regulations. And you're not really allowed to say, oh, I won't talk about that, because the regulations say you do have to talk about it. Firstly, you need to talk about measurements. You probably do that anyway. You can use a not to scale plan. You need to talk about the measurements of the building and also the rooms in the building, if that's applicable. If there's a lease, you need to give details of the lease. There's various provisions you need to provide. And if you don't have them, obviously, we can always help with providing details. So you might, for example, be selling a long lease. Now, the section which perhaps might surprise the surveyors among you is that there's a section which says that the surveyor has to detail easements and restrictive covenants affecting the property. And that's not dissimilar really to doing a title report. Now, you might say, oh, crumbs, why should we be doing it? That should be down to the lawyers. And that is a very fair question. But the regulations do say you are supposed to go through those. I've found a number of ways to deal with this. Sometimes we give a section about the title, and the surveyor might then say in his or her report, we understand from DMH Stallard that, and then talk about what the title report is. You might be able just to refer back to a title report. So, for example, if you're selling a property that was bought a year or so before, you might say, the surveyor might say, I understand the trustees have got a report from 2 years ago. The details of the title are set out in that. Or you might even, I suppose, attach the title. But you do have to deal with it in one way or another. And however tempting it is, I don't think you can just say, we assume there aren't any title issues. The other points are easier. Repairs, the surveyor has to report whether the property is in repair and whether the charity should carry out any repairs before the sale. So you have to consider whether it would be better to sell it in a dilapidated state or in a state with the repairs carried out, but with the charity having paid for repairs. The surveyor has to comment on whether alterations are required to the property before the sale, and also to say whether a delay is recommended. We don't often find it is, but I suppose if the charity was going to carry out repairs, then a delay might well be recommended. Next slide, please. Very importantly, the surveyor has to report on the best way to dispose of the property. And here advertising is crucial. So unless there's an exception, normally the surveyor will be recommending that there's a good deal of advertising for the property. The surveyor will know where to do that, all the people who might be interested, and then they'll report on what has happened in the advertising. You do get some exceptions. So if, for example, a charity is granting a lease to a protected tenant under the 54 Act, well, there's no point in doing any advertising because you've got to grant it to that tenant, so it would just be a waste of time. There's another one which is more tricky. If the sale is to a person that the surveyor thinks has a special interest and the price is more than you get otherwise, the surveyor can say that in his or her report. So, for example, I suppose you could be selling the land to the person next door who's paying much more than anyone else would pay. That would be a case where the surveyor might advise the trustees that advertising isn't needed. The surveyor is supposed to talk about VAT, or there's a get out here. The surveyor can say they're not able to talk about VAT. Then the surveyor obviously talks about the value of the land, what they think the value is, or the rent that should be obtained. And ideally, the report would end up by saying the terms are the best that can reasonably be obtained for the charity, because then the trustees have got exact wording they need under the Act. Next slide, please. Those are the main principles in the Act. There's quite a lot behind the scenes that we as lawyers have to deal with. In transfers, leases, you need to put certificates, effectively setting out that this is land to which the Act applies, and the trustees have dealt with the provisions under the 2011 Act. If there's an agreement for lease or an agreement for transfer, wording needs to go in there. that wording is very important both for a transfer seller and buyer, because if it's not in there, the buyer won't be able to register the transfer. So it's absolutely crucial. You get a hint as to whether you need it, because on the registered title, if there's a charity owning the property, there will almost certainly be a restriction which deals with the Charities Act 2011. If it hasn't been changed for years, it might refer back to the 1993 Act, but you now just deal with the 2011 Act in the transfer. So there's lots of wording we as lawyers need to put in to make sure it all goes through smoothly. Well, I've talked mostly about sales and disposals by charities. What about acquisitions? Well, there's much less in the Act about acquisitions. You need to have certain wording in, again, transfers. If you transfer to a charity, there's got to be a statement that it is being held by a charity. Then the Land Registry know to put that restriction on. But otherwise, there's not much in there. I mean, in practice, I'm absolutely sure that charities buying land or taking leases will take proper advice from a surveyor and require that. But there's much less about that in the Act. It focuses much more on disposals. What about when you need an order of the Charity Commission? Well, you do get circumstances where that happens, or when it's faster. I've had a situation where a charity plus another company have had a lease of a shop, for example. It's been decided that the next lease, the renewal lease, will just be granted to the charity. The landlord's quite happy with that. The difficulty is you've got to bring the old lease to an end. And it won't really happen under the 54 Act when you're changing tenants. So the way that normally happens is you have a separate deed of surrender from the charity plus the other company just before the new lease is granted. You do need to comply with the Charities Act, and that's quite a tricky one, I think, possibly for a surveyor to do, because it's just being done at the same time as the lease, because you've got to bring that old lease to an end. Now, on a few occasions there, I have applied to the Charity Commission for consent. You tell them what's happening, you give them details of the surrender and the lease, and then they will normally write back, and as long as they're happy with it, they may well ask some questions. They'll give you a draft order authorising the surrender, and that's worked well. The one issue there is that the Charity Commission are very helpful once they get to deal with the transaction, but I think they're very busy and have quite a backlog, and it sometimes takes a little while to get your document to the top of their pile, as it were. But as I say, very helpful when you get through. Last 2 points, mortgages. That's also covered by the Act. I very, very briefly, just to say, for those of you who deal with secured lending, charities have to go through hoops if they're granting charges. And in this case, unsurprisingly, the reports have to be by accountants advising on the terms of the loan. So similar to the sale, but from an accountant. And again, you need provisions in the charge to make sure that will then be registered at the Land Registry. Last point, some of you may have come across the official custodian for charities. I come across that occasionally. It was perhaps more used in the past where you had individual trustees of charities, and you didn't want to have a situation where someone ceases to be a trustee, another person takes over, and you have to keep transferring your property. So what charities often did was put the land in the name of the official custodian for charities, holding for your particular charity. Then it didn't really matter if the trustees changed. And in most circumstances, you can sell or grant leases without actually going to ask for the official custodian to sign anything. The charity, in most cases, is allowed to sign it for the official custodian, although the official custodian does need to be a party to the documents. That's a little whistle-stop tour. I hope that's useful, especially for the surveyors among you who deal with sales of charity, just a reminder of what's required. I'm now going to step back and I will hand over to Chloe, who's going to give you an update on planning and the high street.
Thank you, Jonathan. Morning, everyone. I'm Chloe Karamian, a partner in the planning team at DMH Stallard. And as Jonathan said, I'll be talking about planning and the high street this morning. Can I have the next slide, please? Only last week, the government published its Build Back Better Streets strategy. Now, this includes two sort of main proposals for planning in its improvement of the high streets, and I'll be talking about those this morning. The high street has felt significant changes over the last few years due to the impact of online shopping, and that's just been magnified as a result of the pandemic, with us all staying at home and shopping online. The government knows it needs to do something about this. The high street is just not the same as it was. Walking along a high street now, a lot of the bigger players have left, such as Debenhams, and we're seeing a lot of smaller vacancies, smaller shops vacant too. as I say, this is the point of the strategy. The government has pointed out that in 2020, 72% of all retail sales were made in store. So a lot of money is changing hands in the high street, let alone the millions of people employed there, the landlords of the commercial properties and the associated businesses surrounding the high street, which rely on it, including taxis, transport, cafes, cinemas and the like. So that's the purpose of their strategy. Next slide, please. The first point of their strategy in planning terms is the new use class E. So this new use class came into play last summer. It's the commercial, business and service use class, and it is so wide-ranging that it actually spans 2 slides. So we can see on this slide that the new class E includes retail, restaurants, cafes, financial services, and on the next slide, we'll see thank you. We'll see indoor sport, recreation or fitness, creches and offices and other uses such as research and development or industrial processes which can be carried out in a residential area without detriment to its amenity. So it's an extremely wide-ranging use class, and I think they're all uses that we would find acceptable or expect to see on a high street. Next slide, please. As I say, these changes, the new use class was brought in last summer. These were done by amendments to the use classes order, and that is subject to legal challenge at the moment. It has been subject to legal challenge in the High Court and it was unsuccessful. But in the last 3 weeks, we've heard that it's been given permission to appeal to the Court of Appeal. So this leaves a little bit of a question mark over the changes in the new use classes, but it's still good law and we should continue to use it. We'll wait to hear more as to what the outcome of the Court of Appeal case is, and I expect it'll be several months until we hear anything further, given the delays that there are currently with the Court of Appeal. And why are use classes important? Why is this use class E important? And the government's noted it as, one of its planning points in its strategy. Well, the change of use within the same use class does not require planning permission. So one can move between uses within the same use class E. And that can only be controlled or restricted in limited ways. So through existing planning condition or existing Section 106 agreement. So anyone within a Class E could move without needing planning permission to another use Class E. The purpose of this, as the government points out, is to diversify the high street. It will allow businesses to diversify their offering or allow new tenants to come into vacant stores, doing something slightly different without needing to go through any planning hoops. Obviously, I think this is going to be, or this has been welcomed by landlords who have always got more tenants potentially interested in their properties without needing to go through planning processes, and the same for tenants who can now diversify their businesses or look at different properties without needing to go through any administrative steps on the planning front. And I'd be interested to hear from any surveyors or valuers who we've got listening this morning as to their experience of Class E and how this is being received by landlords and tenants, and particularly any issues that are arising and how it's being dealt with in terms of valuation of properties and on rent reviews too. But from a local authority perspective, there may be some concern because this does take control away from a local authority. Unless there's an existing planning condition of Section 106 agreement in place, an authority can't prevent this change of use within Class E occurring. And you can't just, a local authority can't just impose a new planning condition. There needs to be a planning application and it would be imposed on that. So I wonder if we'll be seeing more such planning conditions coming forward on any Class E developments being applied for in the future. Okay, next slide, please. Looking at the other sort of planning point that the government has made in its Build Back Better Streets strategy, that's permitted development rights. Permitted development rights are basically planning permission granted by the government through order. So it literally lists what you can do without needing to apply for full planning permission. A lot of these permitted development rights do require a light touch application known as a prior approval, which is still an application to the local authority, but only on the limited matters that are set out within the permitted development right itself. The government has reminded us that last year it introduced 2 new permitted development rights, which were very important, they felt, to the high street, and these are the upward extensions on residential or mixed commercial residential buildings, and a permitted development right to allow the demolition of vacant detached commercial or industrial and their rebuild for residential. The government's building on that as they're introducing a new permitted development right in effect from the 1st of August. And that's allowing a change of use from Class E to residential. So any of those uses within Class E that are listed in the slides previously can now change to residential without needing full planning permission if the permitted development right applies. The permitted development right is subject to a number of conditions. I've listed a few of them here. A prior approval application is needed to be made for matters including transport, flooding, noise, light and amenity. The Class E property must have been vacant for a continuous 3-month period prior to the date of the prior approval application. And the government has clarified that vacancy due to coronavirus will not be taken into account if the tenant or the owner has actually been in occupation of the property during that time. It's also a requirement that the property has been in Class E use for a continuous 24-month period prior to the prior approval application being made. Now, obviously, Class E only came into play last year, but the government's clarified that this includes any of the previous uses that now form use Class E. And I don't expect that we'll be seeing Debenhams or any of the bigger vacant stores taking advantage of this, because there's a limit on the floor space that can be applied for under this, and that's 1,500 metres squared. It can't be any sensitive locations such as listed buildings, area of outstanding natural beauty, national parks and the like. And importantly, the government has put a limit saying that the permitted development must complete within 3 years of the date of the prior approval. And that's the government trying to get regeneration going and development actually completed quickly, having had concerns that, you know, development was dragging and delaying. So this new use class and the previous this new permitted development rights, and the previous permitted development rights that the government has recently introduced all permit residential pretty much within kind of commercial areas. And there have been concerns raised. And actually this morning, a government committee released a report looking into permitted development rights and specifically this new change of use from Class E to residential. Now, because the report's only been released this morning, I've only read the headlines, but it's quite strong. They're saying that the government should put a pause on this Class E to residential permitted development right. They have got serious concerns about the long-term impact of this change of use, particularly with ground floor premises, whereas we normally see flats above shops on a high street, and I think that would be, you know, typical and acceptable to people. That the committee is concerned about losing ground floor premises and the impact that will have on the high street and the loss of commercial units in the long run. The report also suggests that if the government wants to go ahead with this, that the 3-month vacancy should be extended. They think that that's not long enough, or that it should be proved that the Class E use is no longer viable before it's permitted to move to residential. So that report's only just come out this morning. We'll have to wait to see if the government does make any changes or does pause the permitted development right. I don't imagine that they will, given that it's due to come in next Sunday, and it may be that in the long term or in the near future they make some changes to that. So we'll just have to wait and see what happens, and we will update you. And if you are interested in this, please sign up to our blog posts and our newsletters, because we will be releasing more information as we know it. So next slide, please. Bearing in mind those concerns from the committee, these are the kind of concerns that a local authority may also be having. How can they control these permitted development rights within their authority and try to secure and retain their commercial floor space? Permitted development rights can only be removed or limited in very, very limited ways. Planning condition or Section 106 agreement, similarly to, as I mentioned before, with the use Class E and that change of use, that would only apply to any existing planning permissions and existing planning conditions restricting permitted development rights. And similarly, the same for Section 106 agreements. the more usual way for local authorities to protect their high streets and their town centres are Article 4 directions. They are effectively an order given by the local authority relating to a particular area and removing a particular permitted development right from that area. We saw a number of these coming forward when the government announced its office to residential permitted development right, which made headlines several years ago. For example, I know that Crawley Borough Council have got an Article 4 direction protecting Manor Royal, which is its sort of commercial industrial estate, from that office to residential permitted development right. And a number of other authorities have got Article 4 directions protecting their town centres, such as the London Borough of Richmond, I know, has one protecting its town centre to try to secure its office space to prevent becoming residential, as I imagine that's, obviously a highly desirable area to convert to residential. So the government has said that any existing Article 4 directions relating to that office to residential change of use will continue to apply only until 31st of July 2022. And any authorities wanting to impose new Article 4 directions are now subject to a new test. Previously, the requirement for imposing an Article 4 direction was where it's necessary to protect local amenity or the well-being of an area. On Tuesday, the government released a new national planning policy framework, and that contains a new test for Article 4 directions which restrict change of use from non-residential to residential. And it's a much more difficult test to pass. It is where it's necessary to avoid wholly unacceptable adverse impacts. This could include the loss of the essential core of a primary shopping area, which would seriously undermine its vitality and viability, but would be very unlikely to extend to the whole of a town centre and should be applicable to the smallest geographical area possible. So clearly, local authorities now are subject to a much more difficult test to try to get an Article 4 direction in place. It takes an authority at least 12 months to put an Article 4 direction in place. And so any local authorities listening, I would suggest you'd want to be starting to review your position now and considering whether you want to do this, where you want to do it, and getting the evidence together to demonstrate that it meets this test and get the ball rolling. And any developers or agents who are acting for people who may be interested in relying on this new permitted development right, I would suggest start getting your application together for prior approval and get on with it, just in case the government makes any changes as a result of the committee's recommendation, and in case a local authority does start making an Article 4 direction. As I say, that typically takes 12 months, so there's a bit of time, but it's better to get applications in sooner rather than later. And that's all from me this morning. I'll pass on now to Emily, and if you have any questions, then please don't hesitate to put them in the Q&A. Thank you.
Thanks, Chloe, very much indeed. So yes, finally, I just want to take you through the survey results we received to a survey that we sent out over the last couple of months, taking a view on how our clients and our contacts were viewing the space that they had been occupying during the pandemic in terms of their commercial space, and also what they saw the workspace going forward would be and look like post-pandemic. So next slide, please. So we sent out this survey across the whole variety of sectors that we work for. So not only property, but banks and financial and employment, etc. The majority of the responses we received was from the property sector and professional services. So most were pre-pandemic office occupiers occupying as tenants rather than owner occupiers. And we wanted to get an idea of how expectations around the workplace had changed as a result of the pandemic, and whether effectively destination office was dead. Would we all be continuing to work solely from home? We also wanted to gather ideas about what are the lockdown lessons learnt from when it comes to how and where we work. Next slide, please. What was very clear is that there was going to be and had been a certain amount of reduction in commercial office space from our clients and contacts. More than 1/3 reported that they had already reduced their commercial office space footprint a year to May 2021. And of those, 1/3 had planned reductions pre-pandemic, but over half had attributed that reduction directly to COVID. And we got comments about how medium-term plans had been to downsize, but COVID brought this on faster and to a greater extent. Nearly 1/3 had expected their office space requirements to change in the coming year, and 81% of those anticipated a reduction by this time next year, but only 20% expected to see an actual increase in their commercial office or workspace footprint, which I think is no surprise to most of us. Next slide, please. And it was very clear that hybrid working is something that is here to stay. A significant number of the businesses that we got responses from had already adopted some form of hybrid model of flexible working even before the pandemic. But what was interesting is that it didn't apply necessarily to the whole of their staff and employees. Only 40% were allowing a majority of their staff to work flexibly. So a large proportion would have been 100% office-based. The vast majority anticipate now working patterns to change through the next year, with many and most of those employees working on some kind of flexible arrangement. 87% of those that replied to our survey will in fact be encouraging some form of flexible working, so that your normal working week would be split between home and office. And in fact, what I found interesting is 27% of respondents suggested that some people will not be required to return to the office or the workspace at all, and they will be working from now on 100% out of the office. Next slide, please. So in terms of what we deal with day to day, the landlord and tenant relationship, how does this affect landlords? Well, it's good news, I think. 76% of our respondents still think there is a need for commercial workspace outside people's homes, so some form of central office or hubs. And a further 17% that there is certainly less need, but there is a need. So we didn't get responses saying that there will be absolutely no office or commercial workspace going forward. The key drivers are, as you would expect, the need to somewhere to collaborate, somewhere to train, and generally staff welfare in coming together as a group. We had some great comments about how people feel about the offices, and I've put a couple up on the screen. Next slide, please. So what is the office? What is its role going to be? Well, from a DMH perspective, I think it mirrors a lot of what the responses that we received from the survey said. I think we feel that we need an office to avoid having some kind of fragmented collection of lawyers all working remotely and independently. That's certainly not us as a firm. We see it as important that our clients and contacts get a feel for us as a company as well as individual lawyers, so they know our ethos, our values, and how we project ourselves as a law firm. And I think our offices work as that kind of shop window as to what we represent, very much so. From an internal perspective, the office grants us the ability to interact with each other, with our colleagues face to face, not so much in formal meetings, which obviously can be done by Zoom, but more that accidental meeting in corridors and breakout areas, that chance to just discuss challenges we're facing on matters or indeed victories that we've achieved. I think the office also is important in terms of attracting the next generation of lawyers. of talent from the talent pool. We know that they'll make their decisions about a company partly on its image and its values, and I think they're best demonstrated from the communal workspace that they see. And of course, as with many other professional services as well, our trainees and junior lawyers will also need to absorb and learn and gain knowledge from sitting alongside their more experienced colleagues, which is so important not only to us, but obviously to our clients, so that they know that even the junior lawyers and trainees are gathering that knowledge. And how we work for our clients has to be innovative. We've got to stay on top of things. We've got to evolve. And I think innovation works best when people are in the same room, pooling ideas and bouncing off each other, which needs to be done, obviously, in a communal space. So certainly as far as DMH is concerned, and it seems the case with many of the respondents to our survey, that there will be a balance between home and office working going forward. We all recognise that for some, the office is the place to concentrate, is the place to do the detailed work, because the home environment doesn't necessarily offer that for everybody. It might be more hectic, it just may be less suitable. For others, the quiet place will be home, and the office will be the essential sort of collaborative social hub for the firm. Okay, next slide, please. So these offices that we will be retaining, a large majority of us, what will they be looking like going forward? Well, according to the results of our survey, everyone was more or less looking at changes to that space, to the configuration and use of it. The obvious things that came out of it, we're looking at reduced density of desks, more meeting spaces, and designated social spaces were all key considerations. Many businesses, 60% of our respondents, are also returning to their workspaces with a growing recognition of a greater energy efficiency need. Examples that we were given were electric charging points for vehicles, paper-free environments, greater recycling facility, and the provision of cycle racks. And of course, technology, which has played this huge role for all of us in keeping us connected, will clearly become even more important as we go through this hybrid working world going forward. And I think that means landlords in this new world, wanting to show that kind of competitive edge, will need to invest in new technology for their buildings. I mean, whether we're going to see buildings that are able to track and recognise us from the data supplied in our smartphones as we walk through the door, or have UV lighting which automatically sanitises workspaces after hours, we'll have to wait and see. Next slide, please. So in terms of final thoughts from me, we've certainly seen as a firm that there has been a strain on the landlord and tenant relationship during the pandemic. Tenants have fallen into arrears, not particularly surprisingly. They've sought to renegotiate their leases with landlords, but landlords obviously have their obligations to collect in those rents, and can only go so far. So I think that relationship may need some healing, but going forward, I can see that we'll certainly be encouraging all our landlord and tenant clients to collaborate to find a solution as to the way to work in this new commercial workspace world. It seems there will be pressure on landlords of commercial workspace to think a bit outside the box, to create more attractive spaces, to maybe let to more discerning office occupiers, making that space smarter, maybe offering fit out or certain services as part of that package. I mean, the surveyors in our audience will know far more about this than I. And we may perhaps be seeing more multi-tenanted space rather than single large corporate buildings being taken. The leases that will come across our transactional colleagues' desks will no doubt be slightly different. We're expecting them to be more flexible, to see more breaks in there, shorter terms, and of course maybe a standard pandemic rent suspension clause. On the flip side, one thing to think about is our other landlord clients, those of our residential property, because of course they're the landlords of many of the flats and houses from which people are now working from home. They may need to check, if they haven't already done so, that those leases and tenancy agreements that they're granting, whether they have prohibitions against this kind of use from these properties. Many have a general prohibition against business use, but that may not necessarily prevent working 2 or 3 days from there. But if there is an issue, then they're going to need themselves to check whether their mortgage terms or their insurance terms, or indeed if they are themselves a tenant under a superior lease, have any provisions which means allowing their tenants and occupiers to work from home would put them in breach. Certainly, we have seen, interestingly, an increase in noise nuisance claims coming in from some tenants of our landlord clients, because of course people are spending more time at home and they're becoming perhaps more sensitive to the noise of works that their landlords are carrying out to common parts or to communal space, or to even blocks that they own adjacent to the tenants. So that's another consideration for our residential landlord clients. I think we can all agree that it's certainly going to be interesting times ahead in terms of working in the property sector going forward. Next slide, please. So thank you very much for listening to us this morning. Obviously keen to address as many questions as we can that have come in, and we've had quite a few. There is, I don't want to overrun, so we'll take some of the questions, and then if there are any that we don't have time to answer, we will follow up with an email to you direct. So if I could address a question, please, to Chloe that's come in. Short and sweet, would an office building that is locally listed affect the PD application?
Okay, so for those that don't know, a locally listed building is a building which the local authority thinks has got some special heritage or architectural interest, but doesn't obviously meet the criteria for national listing with Historic England. So I think this question is asking about the Class E to residential permitted development right, and no, local listed buildings, are not automatically exempt from this permitted development application. It is nationally listed buildings that are definitely not permitted through that, or any buildings within its curtilage.
Okay, thanks, Chloe. Jonathan, I've got a question for you. You mentioned that there are some exceptions where the charity rules on disposal don't apply. Obviously, someone looking for an exception here. What are they?
Yes, there's a few exceptions. We don't come across them very much, but sometimes. So one you have is where you have one charity that is, for example, selling land to another charity other than for the best value obtainable, and where that's allowed by the trusts of the first charity. So that's one exemption, pretty rare, but you do get it. And so the rationale is although you're doing this as an undervalue, it's going to another charity. Otherwise, there are quite a few exempt charities, i.e. ones that aren't registered with the Charity Commission. Examples would be, you've got some museums, universities, sixth form colleges, so some educational establishments. In those cases, some of those charities won't have to go through the procedures I talked about, getting the detailed surveyor's report. They do actually have to still comply with some of the other provisions of the Act. I think the rationale there is they will often be regulated by other legislation, so they don't need to be regulated so much by the 2011 one. And lastly, there are some bodies that are just outside the scope of the 2011 Act. I've not really come across these, but bodies relating to the Church of England can often just be without the scope. So if you come across the exemptions you're not sure about, just let me know.
Okay, thanks, Jonathan. Just want to read a comment that we've had in, which I think is probably welcome. Someone saying that our experience has been that the new Class E has opened up the market in a very positive way and has been welcomed by landlords and tenants. I don't know if that's something you've heard before, Chloe, in terms of Class E.
Yes, I think so. I think that was what I was hoping people would say, that they've found it useful and that it was allowing tenants and landlords to diversify or look at different properties that maybe they weren't anticipating, because they wouldn't need to apply for planning permission to change that use.
Great, okay. I'm conscious we've got a number of other questions that we haven't addressed, but it is 11 o'clock and I don't want to keep anyone any more than the hour. As I say, we will come back on those questions to you direct, so you will have answers to those. We'll be also sending you a copy of the slides from this morning by email, so you'll receive those shortly. And we very much hope you can join us again at our next seminar, which will be in September. Details to follow, and you'll receive an invite. If you have any colleagues that aren't receiving invites at the moment, then obviously please do share those details and we will send them invites also. So thanks very much again, and we will see you soon. Goodbye.